Okay, we're on the record. This is People versus Carlos Lorenzo Durham. Case number 2259974. Count one. Only count one. Police officer resisting and obstructing. This is a habitual offender fourth offense notice. And also case number 2258771. People versus Carlos Durham. Durham is charged on this case with count one, weapons, firearms, possession by felon. Count two, weapons, felony firearm. Count three, weapons, ammunition, possession by felon. Count four, weapons, felony firearm. Count five, carrying concealed. Count six, police officer assaulting, resisting, and obstructing. And this is a habitual offender fourth offense notice.
In this case, we're watching one of the most classic clashes you can find inside a modern courtroom. A defendant who thinks he's discovered a secret rulebook versus a judge who actually has to follow the real one. Carlos isn't just walking in with a simple misdemeanor or a bad driving ticket. He's loaded with multiple felony allegations and wrapped in layers of sovereign citizen ideology that he seems determined to test against the legal system. What makes this so fascinating isn't just the charges, but the confidence. Every hearing feels like déjà vu mixed with a new twist, as Carlos bounces between acknowledging the court and rejecting it altogether. You'll notice how the judge keeps her tone calm, measured, and completely unimpressed. That's important. Judges who deal with sovereign-style arguments regularly learn to keep a straight face while defendants talk about corporations, all-caps names, trademarks, and fictitious entities. But behind that calm tone sits real power, the power to jail, to deny bond, and to keep cases moving whether the defendant philosophically agrees with the system or not. And today, as you'll see, Carlos is about to learn that reality in real time. So stick around, because this isn't just a legal process, it's a slow-motion train crash between fantasy and law, and the outcome is impossible to ignore.
Today set for a bond redetermination hearing. Appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Delisha Taylor Coleman, P56278 on behalf of Mr. Durham on both matters for bond redetermination.
And Mr. Durham, can you state your full name for the record, please?
Carlos Durham.
Thank you. And whenever you're ready, Attorney Taylor Coleman.
Yes, Your Honor. As the court has before it, I believe Mr. Durham has a capious with this court, or maybe it was with Judge Elise Bryant. At this point, we'd ask for any capiouses to be recalled. That he is a resident of Detroit. He has significant family contacts. I'm looking up his investigation report. I'm looking up the sheet from misdemeanor felony defenders on his behalf. Long story short, we're asking for a personal bond with tether, and that he would reappear at all future court dates.
This is one of those moments where the room suddenly feels heavier, even through a screen. When the clerk reads a list like that, it's not just a formality, it's a roadmap of how deep the defendant is in. Multiple firearm charges, felon in possession allegations, resisting police, and habitual offender enhancements aren't minor footnotes. They're the kind of charges that follow you for years and stack sentencing exposure fast. What's striking is how casually Carlos reacts compared to the seriousness of what's being listed. For many sovereign citizens, the focus is on ideology, not consequences. They argue jurisdiction and paperwork, while the court is looking at public safety, prior history, and patterns of behavior. This gap between how serious the defendant thinks things are versus how serious they actually are becomes a recurring theme. And as those charges pile up on the record, you can almost sense the judge mentally moving from maybe to absolutely not on the idea of leniency.
We could address the capious of December 14th, Mr. Durham.
I'm sorry, what did you ask him? I didn't hear the first part of your question.
Address the capious of December 14th of 2022.
Yes, go right ahead.
Mr. Durham, were you aware of that court date?
Yes, and kind of no. They bombarded me with a bunch of court dates, and I kind of might have forgot it because there's so many I got to go to.
Okay,
They
so
sent me about 40 different cards with court dates on them.
you essentially mixed up your court date.
I think so. I got court dates all the way to February, and I think I just missed it out.
Okay. Would you reappear at all future court dates, Mr. Durham?
Yes, I reappeared. I appeared before. I was on Zoom. I was on a tether. I came to court.
Okay. Your Honor, we believe that this was just a mistake, a one-time mistake. Mr. As the court can see in the register of action, Mr. Durham had appeared at previous court dates, but as he stated, because of the number of court dates, this one fell through the cracks. But he would reappear at all future court dates. These are non-assaultive crimes. We're asking for a personal bond, reinstate the bond with tether. Would the court consider any reduction at all? I don't know if Mr. Durham can post any amount of money. Was there a change in your bond before Judge Bryant, Mr. Durham?
So the what? I didn't hear you.
Was there a change in your bond before Judge Bryant?
Yeah, it was a $10 bond. That's all it is. They said it's a $10 bond. I'm here to get this bond reduced so I can get out of jail.
And you have employment?
I work for myself.
Okay, so I'm still going to keep it the same, Attorney Taylor Coleman. Because of the cases on both cases, I am going to wait until we get to the probable cause conference on the 25th with the DSU report to determine whether or not I'm inclined to reduce the charge. I need him to show the court for something because we're back at the probable cause conference. I want you to listen up very carefully. Your next court date is January 25th. That is a Wednesday at 8:30 a.m. Can you hear me?
Yes, ma'am.
Okay, so you'll be zooming in from the county jail, and you'll have an attorney present to discuss with you any matters before we go on the record, okay? So show up for that, well, you have to show up for that. Then your attorney then can possibly discuss something once we have a DSU report, okay? Attorney Taylor Coleman, anything from defense?
That's it. Thank you, Your Honor.
All right, you all both have a good.
The crack in the armor. After months of insisting on alternative identities and family names, Carlos finally answers the most basic question in any courtroom. State your full name. It may seem small, but this is huge in sovereign citizen psychology. These movements are built heavily on wordplay and refusal to contract with the court by stating one's name. So when someone eventually does, it often signals fatigue, pressure, or slowly dawning reality. Notice how much calmer the court interaction suddenly becomes once the formal identity issue disappears. Things move quicker, cleaner, and much more procedural. The judge doesn't mock him, doesn't gloat. She simply proceeds because that's what courts do. Meanwhile, the audience at home is probably thinking the same thing. If he had done this from the beginning, how different might his situation?
Okay, gentlemen from the county jail who just sat down about 5 minutes ago, can you state your name for the record, please?
My name?
Yes, your name.
My name is Carlos Lorenzo, and I'm here to represent the person you got on that paper, which is an all capital name, all capital letters. That's a corporation, and I'm not claiming to be him, but I'm here to represent him. All capital name is all corporation. I'm not a corporation, I'm not dead, I'm not a fictitious entity. So I'm not claiming to be whoever name you have on that paper, which is probably in all capital letters. That's not my name. It's two names in this court that sound exactly alike, and only one of them is mine. What name is on that paper y'all have over there? Is it in all capital letters? That's not my name, but it's my property. It's my trade name, and I own it. And I need to know if anybody has permission to use it from me. So do we have that understood? I am not a U.S. citizen, and I'm not a citizen of the United States. I am not that person on that paper, because that person is a fictitious entity. I am actually flesh and blood. I am a man standing on the land, and that's what I got you to do. You understand that? I'm not him. I'm claiming not to be him.
I just wanted to know who you were. Thank you. I had to check there. Attorney Simon, thank you. You wanna speak to your client in private before we go on the record? Because he's still talking.
Sorry, Judge. Can you repeat that, please?
Do you wanna speak to your client in private for a moment? Because he hasn't stopped talking for the last 10 minutes. He's still talking. He doesn't know he's on mute, but he's been talking.
I just saw him Monday at the jail, but okay.
Okay, because I don't think we can have his hearing unless he understands we all can't talk at the same time.
All right, I'll do a breakout.
The defense attorney is doing exactly what she's supposed to do. Advocate hard for her client, even when the situation looks grim. She highlights ties to the community, family connections, and the idea that missed court dates were confusion rather than willful avoidance. This is classic bond reduction argument territory. But the problem is that judges don't just listen to promises. They look at patterns. When someone has already missed court, has multiple open cases, and has serious felony charges involving weapons, judges start thinking about two main risks: failure to appear and danger to the community. Those two words, risk and safety, carry more weight than fancy legal jargon about sovereignty or paperwork. So even while the defense builds the best narrative possible, you can almost feel the judge mentally stacking the red flags higher and higher as each fact is mentioned.
Okay, we're on the record as the people versus Carlos Lorenzo Durham, case 2259974. Mr. Durham is charged with one count of police officer assaulting, resisting, and obstructing. This is a habitual offender fourth offense notice. Also, case 2258771, the people versus Carlos Lorenzo Durham. Mr. Durham is charged with count 1, weapons, firearms possession by a felon. Count 2, weapons, stony firearm. Count 3, weapons, ammunition, possession by a felon. Count 4, weapons, stony firearm. Count 5, carrying concealed. Count 6, police officer assaulting, resisting, and obstructing. This is a habitual offender fourth offense notice. Today's the day set for a probable cause conference. Appearances.
Alexander Kirker on behalf of the people, P8628.
Good morning, Your Honor. Jonathan Simon, P35596 for Mr. to both matters.
And Mr. Durham, can you state your name, please?
Objection, I'm not a mister. I just told you that it's two names that sound exactly alike and only one of them is mine. My name has never been spelled in all capital letters, so that is not my name. Whatever name you have on that paper is a corporation and it does not exist. That's not who I am. I'm not.
What is your name,
I'm here to
sir?
represent him.
What is your name?
My name is Carlos. That's what I go by.
Sovereign defendants hate the most because it removes any mystery. Did you know about court and did you come? A capias, essentially a warrant for failing to appear, is a judge's way of saying the court has already tried trust and trust failed. Carlos' explanation is almost unintentionally comedic. There are just too many court dates to keep track of. That statement alone tells the judge exactly why bond is risky. The justice system cares less about philosophical arguments and more about behavior. If someone already showed they won't consistently appear, why would the court gamble again, especially with felony charges? His answer paints the picture of chaos, multiple cases, multiple dates, confusion, which is the exact opposite of what a judge wants to hear when deciding whether to let someone walk out of jail pending trial.
State your name, please.
Objection, my name is not Mr. and I never spelled it in all capital letters. I keep explaining that to y'all, but y'all insist I'm that dead entity on that piece of paper, and I'm not.
What is your last name?
What is your name, ma'am? Can I have your name and your oath of office, please? Did you take an oath to uphold the Constitution, ma'am? Or did you take an oath to violate my constitutional rights in conspiracy with the prosecutor and the Detroit police?
Attorney Simon, what I'm getting here is that Mr. Durham is not present.
Objection, I'm not a Mr.
I can enter a capias because that's not Mr. Durham. Or
Judge, maybe we could have a competency referral.
he knows what he's doing.